Good afternoon, and this is the first meeting of 2026 for the Committee on Public Safety and Military Affairs. This meeting is being streamed live on YouTube, so in the unlikely event that we have to end this hearing due to technical difficulties, the committee will reconvene to discuss any outstanding business at 3 p.m. Friday, January 30th in room 229, and a public notice will be posted on the legislature's website. We have a somewhat abbreviated agenda this afternoon. One bill was removed. However, we do have some important topics. Each testifier will be given 2 minutes to testify. And if you have already submitted written testimony, we want to encourage you to hit the important facts or standing on your testimonies. So first up, we have Senate Bill 2145 relating to recordings of law enforcement activities. And I believe we have for the Office of Public Defender, John Ikinaga. Is anyone from Public Defender present? Okay, if not, they have submitted written testimony in support. Next, we have Maui Police Department. They have submitted testimony in opposition. Honolulu Police Department, I believe we have, let's see, Arnold Segusio testifying on behalf of HPD. Is he available?
Not present on Zoom, Chair.
Okay, we can come back to that individual later on. Next, we have Douglas Miller testifying for League of Women Voters of Hawaii. Let's see, written testimony was provided. Next is Chris Caulfield testifying for Imoa Alliance. Okay. Next is Gerald Kato testifying for Media Council of Hawaii. Members, most of this is all in written testimony in your master testimony file. Following Gerald Kato is Austin Shiloh Martin for Libertarian Party of Hawaii. I believe he is available on Zoom. Welcome.
Thank you, Chair. I appreciate it. I'm Austin Martin. I'm the chairman of the Libertarian Party of Hawaii. I'd like to affirm my written testimony with a caveat that some of the bills that I presented testimony on may have gotten swapped. And so if you notice that, my apologies, guys. And thank you. I might be switching in and out. So thanks to the administrators for running the Zoom. This is so important. We need the ability to record interactions with law enforcement. It's absolutely critical. And I stand on my written testimony on this. This bill explicitly establishes a statutory right for any person to record law enforcement activities in public. That needs to be established. It's often misunderstood and leads to serious rights violation. It needs to be distinguished as a right and a First Amendment protected activity. It should already be protected, but I think this is a helpful step, and I really appreciate this bill and thank its introducers.
Thank you very much. Members, any questions for Mr. Martin? Okay, if not, next we have Josh Frost for ACLU of Hawaii. Oh, welcome.
Good afternoon. I'm not Josh Frost. My name is Mandy Fernandez. I'm the policy director with the ACLU of Hawaii. We are in strong support of this measure. We know that the First Amendment very solidly through case laws supports the right to record officers when they're performing their duties in the public and in clear view. What this does is it puts a statutory right on the books to clear up any confusion about this, to make sure that officers are in notice that this is a right of the public to record them when they're carrying out their duties. This would also apply to federal agents as well. What we've been seeing out in Minneapolis is absolutely horrendous, with ICE officers telling people to stop recording them or trying to intimidate them to stop people to stop recording them. Something that's really important is that this would establish a private right of action. And so what that does is it offers recourse that wasn't there before if someone's rights are violated. Thank you so much. I do hope you pass this measure today.
Thank you very much.
Thank you.
I have a question.
Okay, Senator Inoue. Yeah.
Yeah, this sounds familiar. Was there a court case on the mainland with regards to this particular issue?
Yeah, so this has been litigated pretty extensively, and there have been a number of court cases affirming this right. And I think most circuits.
Do you know what the outcome of the court cases were?
Yeah, so the outcome was that courts have pretty consistently ruled, or have consistently ruled that this is a First Amendment right. So as long as you're not obstructing, it doesn't give you the right to obstruct law enforcement operations, and this bill would not give you that right. It wouldn't give you the right to trespass to go record police operations. But if if an officer is in clear view, it would give you the right, or it would just reinforce the right.
Okay.
Yeah.
Thank you. Thank you, Chair.
Okay, members, any further questions? Okay, if not, thank you so much.
Thank you so much.
Thank you for being here. Okay, next we have Judith Mill Wong from League of Women Voters, who have submitted testimony in support. Members, most of the testimony has all been in support, with the exception of the two testimonies from the police departments on Maui and Oahu. Next is Elizabeth Jubin Fujiwara for Fujiwara Rosenblum LLC. See, testimony in support has been submitted. Mo'i Ka'avakoa testifying for Holomua Outreach, also in support. The next group of testifiers have submitted primarily written testimony, so I'm just going to read their names. I don't believe they intended to show up at the hearing or testify via Zoom. Victor Ramos, individual, testifying in opposition. Spencer Pote in support. Scott Smart in opposition. Sandy Ma, Veronica Moore, Sam Guckenheimer, Allison B, all in support. Next is Doris Siegel Matsunaga in support. Stephen Munkelt testifying for Hawaii Indivisible State Network in support. Georgette Yindel testifying in support. Nancy Moser in support. Judith White in support. Tim Puig in support. Lorna Holmes, Mona Isa in support. Susan Paola Davis, Margaret Sipple, Kevin Hughes, Tammy DiBernardi, Marcella Alohalani Boydo, Yoonghee Overly, Michelle Bonk, Martina Wong, Julie Walters, Kahala, Matt Brown, Giselle, White T. Martin, Elena Arinaga, Christine L. Andrews, and Clayton Kamita, all in support. Is there anyone else who would like to offer testimony on Senate Bill 2145?
Guys that came in late to testify. Earlier, you had
Okay, any others who would like to comment on Senate Bill 2145? Are you here to testify on this measure? Okay, thank
I
you.
guess they're not.
Okay,
They're not.
turning to the next measure, Senate Bill 2151 relating to emergency management. On this measure, we have testifying for Office of Information Practices, Carlotta and Marino, who have submitted written comments. Also, we have Hawaii Emergency Management Agency Administrator Director Barros in person. Welcome.
They're the one
Hello,
that-
Chair. Vice Chair, Senator.
Yes, aloha.
Hello.
Aloha.
James Barros, Administrator for Haima. We submitted testimony in opposition of this bill, and we stand by our written testimony.
Okay, thank you very much.
Thank you.
Please stand by for questions. I'm sure we'll have some.
Yes, ma'am.
Thank you. Okay, next we have, let me see. Douglas Miller testifying for League of Women Voters in support. Wayne Chung Tanaka for Sierra Club of Hawaii in support. Ted Kefalis for Grassroots Institute of Hawaii in support. David Henkin for Earth Justice, written comments in support with proposed amendments. I believe he is joining us via Zoom. Welcome.
Thank you very much, Chair and Vice Chair and Senator. You have our written testimony. What I'd like to emphasize in this oral testimony is that with the NACOA decision from the Hawaii Supreme Court, the court gave a very, very broad reading to the emergency powers that Chapter 127A provides. The governor is empowered, in the view of the court, to invoke emergency powers, including suspending this legislature's lawfully enacted statutes whenever there is an issue that is, quote, rationally related to public health, safety, or welfare. I mean, that is virtually everything that the legislature does is rationally related to public health, safety, and welfare. And the court specifically said that emergency powers are not limited to sudden or unexpected events, which I think is what immediately comes to mind with emergency powers, things like tsunamis or the COVID pandemic or terrorist attacks, or there are a variety of things that are sudden emergencies. But the court found that even long-term public policy issues could be subject to the governor invoking emergency powers and suspending this legislature's statutes. So we strongly support the bill that is before you, and we feel it doesn't go far enough because the only way that this legislature could respond if the governor, and it's not this governor, it's any governor or any mayor at the city council, at the county council level, anything inappropriate, the only way to respond would be with a supermajority. And you know how hard it is to pass bills. It's really hard to do things by supermajority. And if the emergency proclamation is issued when you are not in session, you'd also have to call a special session. That should not be. We've suggested some language to address the Supreme Court's ruling that emergency powers under 127A are not limited to sudden or unexpected occurrences. We're not wedded to the specific language that we have proposed, although we understand that there is a companion House bill that's being introduced that will have this language. But there has to be something in Chapter 127A to make it clear that the governor can use emergency powers and the mayors can use emergency powers only in what are true emergencies, things that do not allow enough time for this legislature to respond in the next legislative session, things that are not long-standing public policy issues. Thank you.
Okay, thank you so very much. Other questions? If not, please stand by because we may have questions to follow up with.
Be happy to.
Thank you. Next, we have Ben Krebs testifying for Public Law Center, offering comments.
Yes. Hi, good afternoon, Chair, Vice Chair, and member of the committee. My name is Ben Krebs. I'm a staff attorney at the Public First Law Center. We're a nonprofit dedicated to promoting open government in Hawaii. We strongly support the intent of this measure. You know, we do need a healthy tension between our executive and our legislative branch, and this bill is definitely a step in the right direction. And we do offer a friendly amendment in our testimony. So right now, this bill as drafted carves out one part of the public records law from the governor's ability to suspend the public records law, but there's 4 parts to the public records law. And so our suggested amendment is to carve out the entire public records law. And I did have the opportunity to review some of the written testimony and particularly the testimony in opposition. And I do believe that as written, this bill does address the concerns that were raised in the opposition testimony. And that's one, that this bill does provide for reasonable delays and extensions when necessary. I would also point out that there's an existing exemption under the public records law that agencies can withhold records if it frustrates a legitimate government function. And that's an exemption that the Department of Defense or Hawai'i can avail themselves of under existing law. So we think this is a good measure, and we request that you pass it favorably. Thank you.
Thank you very much. Let's see. Next, we have Austin Martin testifying for Libertarian Party of Hawaii on Zoom. Mr. Martin, please proceed.
Thank you, Chair. I really appreciate this issue, and I want to stand on my written testimony, but I also want to add a personal little anecdote for why I'm here today. There's a whole lot of bills you'll notice that I've provided testimony on, and I'm the chairman of the Libertarian Party of Hawaii. My name's Austin Martin. If you haven't met me yet, you'll get to know me. The reason why is because of Chapter 127A. Shortly after I moved to Big Island, I was arrested and charged with a pretty significant crime of violating the Governor's Emergency Powers Act and the absurd strict interpretation that it got for political selective enforcement. What I did, my crime, was calling COVID mandates Nazi policy. I was angry about it. And I'm not proud of, letting that slip out that way. But at the same time, that's my First Amendment. I was arrested for that and charged, and the charges were maintained in court for over a year before the prosecution came out and admitted in writing that they had no evidence of any crime being committed in the first place. It was a political targeting event. That is how emergency powers are currently being used in Hawaii. We are really hurting our people by running with emergency powers to override the rule of law and allow the executive to run absolutely rampant. It's lawless out here. We have to stop this. I love the idea of putting a check on this, but this bill is not an effective check. This bill will change nothing, although I really appreciate the intent of putting a check on there. In reality, I think the judiciary should have stepped up and stopped the governor from doing what he's done. And it's not fair that you guys have to pick up the political pieces of the mess that he made for you. And I am sorry for that. But I hope that you guys will do the right thing here and restore the rule of law in Hawaii and reject the extreme interpretation of executive authority.
Thank you so much, Mr. Martin. We appreciate your comments.
Thank you.
Okay, next we have Marty Townsend also testifying for Earth Justice. I believe written testimony has been submitted. Next, Victor Ramos, testimony in support has been submitted. Lila Moray Salvage, testimony in support has been submitted. Is there anyone else who would like to comment on Senate Bill 2151? Okay, if not, members, any questions? I know the, let's see, Earth Justice testifier David Hankin did have some amendments to propose, and Chair did want to go back to him for a couple of questions, you know, in the yes, proposed amendments that you are proposing that cover not only natural disasters, but hazardous material accidents, disease or contagion outbreaks, etc. Do you believe that this list is broad enough to encompass, you know, some of the areas that the opposition had raised as a concern for having this emergency power area limited?
Yes, we do. Basically, one of the problems, I think, with the existing statute is that it does not provide in its definitions of emergency or disaster any examples of what the legislature has in mind. And so the language that we've suggested, which the examples actually come from a bill that is currently stuck in conference from last year's session, House Bill 596. I will note that that language was passed unanimously in both houses. It got stuck in conference. But anyhow, the intent of this language is to be illustrative, not exhaustive. The real key issue and the key thing that the Supreme Court seized on is that there is a statement in Chapter 127A that the legislature intends the emergency powers to be interpreted broadly. And I think that's right, if there is truly an emergency. But then the court interpreted that and said, well, there's nothing in the statute to suggest that it can't address longstanding issues of public policy. And so in our definition, including that it has to be in response to a sudden event, and then the examples provide that respond to what the Supreme Court said. And, you know, in the committee reports, that also suggests that you clearly state that the amendments are being done to respond to the NACOA decision. So the legislative history would be clear that the legislature does want the mayor and the governor to be able to respond to true emergencies, but that the court interpreted that too broadly in the NACOA decision.
Okay, thank you so much. Members, any further questions?
Yeah, Chair.
Oh, Senator,
No,
please,
Senator.
please.
So what we're saying with the amendments, but I note that you do say that the 2/3 of the legislature, that's the current statute, right? The current statute is that it should be approved by 2/3 of the legislature. and this is for both houses. However, but you're saying that this definition also includes limiting the emergency powers in the first place. So, but that's true for the statute. But are you saying to to delete then the 2/3 votes for all emergency powers recommendations?
Well, to clarify, the existing statute does not have the provision about the 2/3 override. That is the new language proposed by this bill. So under the existing statute, there is no way for the legislature to override the invocation of emergency powers. That is the new language. We have no objection to including an override. We're just saying that is not sufficient. So that's the new section E and F. It's in section 5 of the bill. It's in addition to section 127A14. So that's not in the existing statute. We have no objection to including that. What our testimony wanted to emphasize is that alone isn't enough. And you who have served in the legislature for a long time, collectively, I don't even know how many years I'm looking at in terms of service, but you know how hard it is to get bills. You know how hard it is to get a special session. And so, you know, if the governor is invoking emergency powers when you're out of session, or even if you're in session, be very, very hard to get a 2/3 override. And so we need to limit what is an emergency. And that's the language we're suggesting. And this is a safeguard, even in the case of a true emergency. If the legislature thinks it's contrary to public policy, having the 2/3 override makes a lot of sense.
And that's true too, because an emergency proclamation, if it's in a really emergency, you can. It's impossible to have the legislature come back just for that.
I agree completely. And so this 2/3 override would be in situations the court recognized, and I think it's correct, that even with a true emergency, let's say the tragic fires in Lahaina, responding to a true emergency.
Or a tsunami.
Yeah, exactly. Or a hurricane. All of these, you know, the emergency response can take a long time. However, at some point, the legislature might decide that it's time for the legislature to act and suspend and end the emergency. And so I think the 2/3 override makes sense.
Okay, thank you, Chair. Okay, Vice Chair Lee.
Thanks. Sorry, I just asked the question I was going to ask, but maybe for Haima, or for I guess it was Haima, right? Sorry. Yeah. But you guys had submitted testimony on this on 2151 in opposition.
In opposition, yes.
Right. Just to that point that I think the senator had asked the last testifier about identifying some of those key instances of disaster, you know, going back over the last decade or so, or even expanding upon that with COVID and dam breaks and any number of other things that we've experienced here. I'm reading through your testimony and trying to figure out what sort of situation you're alluding to that this measure would impact or prevent proper response to. Like, what's an actual example of that?
So last session, we did oppose the bill that tried to limit and define specifically what an emergency is. Because we want to, from my perspective, from the Emergency Management Agency, we want to be able to look across and be prepared for the unknown, is what we're saying. So you brought up Lahaina, which we got an emergency proc, but that impacted one community on one island. What we're looking at in Haima is we're planning for our worst day in the state, that every county is impacted, every agency, every community is impacted. And that's the kind of emergencies that we're looking at, be it a tsunami that impacts the coastline for every island, or a very large hurricane that we're seeing now. The United States goes to war, and we're now on a war footing at the United States. Hawaii is at the center in the Pacific. What does that mean for us? So that's the kind of flexibility we want to provide the executive to now say, here's an emergency for us. And that first part about limiting access to public records, when we're in a response phase, we're looking to save lives and, address the needs of the people. That becomes almost secondary, sharing the public information and getting that.
Sure.
So we're trying to give as much flexibility to the executive in this disaster, because this proclamation is 60 days, it's in there, and we renew it. And when we renew it, it's a very collaborative across the state agencies on, do we want to renew this and what do we need to keep in it?
Yes, I get that part. I think with respect to the definition of emergency as it's currently defined versus what is being proposed, or in the discussion we just had with the last testifier, whether it's a disaster, which I totally get, like in Lahaina on one island, or there's multiple Lahainas across the state at the same time. What I took away from the last conversation is the emergency proclamation would still apply, and you would still have the ability to declare an emergency for anything that happens statewide under this. But what I was trying to get at is what is the actual, because I get the broad applicability you're talking about, but
Yes.
what's an actual example that would be impacted under this?
Well, I think that first part that you guys want to add, that the governor or the mayor cannot suspend the Public Records Act piece of it. In a larger emergency, we need that time and space to be able to get to those public information requests. For example, Lahaina was a very large event for us. Every agency was involved. We had our PIOs, but there's no way that we can keep up with that. So and I guess from our perspective, you're calling out one piece to in the law that says, hey, governor, mayor, you cannot do this. Where we would prefer that he has that flexibility, that if he needs it in a emergency prompt, that he can do it.
So you're not speaking to the state of emergency section of the bill?
No, yeah, so pretty much.
I guess what I mean
Well,
is the concern is the public records section, not the definition of emergency or the scope of what could constitute a state of emergency as is defined in the bill. Is that
Yes,
right?
sir, it's both. We're looking at both of it, because there's some pieces in there that, okay,
Sure. I guess setting aside the public records portion for a minute, because there's obviously different elements going on here. But just looking at the last section of the bill in section 5, which is the state of emergency portion, just focusing on that for a minute.
Okay.
Is there anything in there that's concerning to you? Or was the testimony really focused on the first section?
I've seen our testimony from Haimo was the overall package, both sides. Yes, sir.
So if let's say for a minute, if the public records section of the bill went away and we're just passing what's in the state of emergency portion of the bill, which I think this last discussion was about, and we're looking at when and for what purposes the governor or executive branch is able to declare a state of emergency and what the scope of that is, and whether or not there's a point at which the legislature then can step in after so much time with a supermajority vote. If we pass just that, then I'm trying to understand what the impact is for some of the potential disasters or situations that you guys would face that would be limiting to your mission.
So our mission at Haimo with the governor, because at the very last line, when conditions weren't, we help him define when we can transition into more of a recovery phase. So I think that makes sense, because that's our job, to help him say, okay, the conditions are met, sir, we're no longer in an emergency. And that's part of our Kuleana. So I would, can I oppose pieces of it. And so as you work through this bill, and it was hard because there's some things we look in and say, okay, I can, that makes sense that when conditions warrant, because that's our job to define that for him. And like I said, when the EP is going to expire across the state, agencies, we come back and say, okay, do we still need the emergency prop? And then we go back with the AG and the governor.
Is there a situation, I wouldn't imagine with this governor, but down the road with a future governor, whoever that might be, that you end up with an abuse of the use of emergency proclamations such that there would be a justification or could be a justification for whatever it is where you'd need someone outside just the governor's executive branch to step in?
Yeah. So
where would that accountability lay?
So I saw this bill adds at the end, the 2/3. I don't know if we need that in 127 alpha because you guys already have that power. The legislators have that power to override an emergency. So I'm not sure if we need to capture that in here when, somebody can introduce something here, get it through both houses and, override the governor on an emergency.
If we were to do that in normal course, wouldn't that require a full session?
I got to check with my legislative experts.
Because under this language, you would only need basically one vote, hypothetically, the way that I'm reading this, versus passing a piece of legislation through the normal process, which would require, a number of other steps over a much longer period of time.
Yes, sir. Yeah.
Okay. Well, thank you.
Yeah. Sorry.
Thank you, Chair.
Senator Inouye?
Yeah, to follow up with regards to having the opportunity to look at the public records. But did you just say that during the wildfire that what you needed to have or asked to look at public records, but you were denied?
No, we didn't deny any of that,
Okay.
but it was delayed. And then when it's delayed, it comes up through you might get a fine. We get letters going, hey, we got to follow up on this.
Can I ask you then, what public records would you need as an example? It could be anything, right? So what would be important for you to?
Well, not
get?
for me, but for the public asking for information from us. Right.
Okay. Got it.
Right.
Got it.
So, and then, we had our public affairs officers really trying to focus on putting out the correct message or correcting some misinformation. So we didn't have the bandwidth at the time to follow up on a lot of this, so it got pushed to the side.
Okay, thank you.
Maybe one very brief follow-up question. We appreciate, the scope of the governor's emergency powers that are needed. However, in the Earth Justice proposed amendments, they did kind of provide a laundry list that seems pretty extensive, including, war or other kinds of actions. So I think if anything, we're really looking to work with your agency to tailor the emergency proclamation type of activity in a way that ensures that we don't have other types of public policy discussions be treated as emergency proclamation type of subjects. And that seemed to have been, the real purpose here. So I think if we, look at the various natural disasters, warfare, bioterrorism, COVID, et cetera, that seems like a pretty broad list. And it's not intended to otherwise limit, the governor's legitimate, areas of jurisdiction. So, perhaps we can kind of look to see the extent to which, there may be parts of this proposed set of amendments that actually would help your department as well as the governor's office frame, the proclamations in a very targeted way that would allow us to move quickly.
Yes, Chair. We look forward to having those conversations.
Okay, thank you.
Thank you.
Okay, any further questions? Okay, if not, let's Oh, I'm sorry, I neglected to identify one of the late testimonies that was received from Department of Emergency Management from the City and County of Honolulu. The department also opposes Senate Bill 2151. And is there anyone from the department here to comment on this measure? Okay, if not, it appears that, they have somewhat similar concerns to those expressed by Hawai'i, and it is, I think they raised some legitimate concerns. But anyway, since we don't have anyone from their office, let's turn to the next measure on the agenda. It is Senate Bill 2030. This one is relating to corrections, and I believe first testifier that we have is Director Johnson. Is Director Johnson present? Oh, okay. Welcome.
Oh, hi. Hello there, Chair Fukunaga, Vice Chair Lee, and members of the committee. I'm Michael Hoffman. I'm the Institutions Division Administrator for the Department of Corrections and Rehabilitation. The Department of Corrections and Rehabilitation supports the intent of Senate Bill 2030. It seeks to appropriate an unspecified amount of funding for all adult correctional officers to wear body-worn cameras while on duty in all state correctional facilities. Requiring to have that ACOs to wear the body-worn cameras affects the conditions of employment because a violation of any body-worn camera policy established by us could result in disciplinary action or dismissal of an employee. The DCR would be required to consult and or negotiate with UPW on this matter, including implementation of any policies relating to the body-worn cameras by our adult correctional officers. Therefore, we, DCR, respectfully request this measure to be amended to allow us the time needed to conduct research into the cost of the body-worn cameras, the cost of data storage, replacement of the adult correctional officer shirts, and consultations with the UPW on this matter. DCR will be prepared to provide a report to the legislature no later than 20 working days prior to the 2027 legislative session addressing these issues. And we thank you for the opportunity to provide testimony in support of the intent of SB 2030, and we'll be standing by for questions if you have any.
Okay, thank you
Thank you.
very much.
Thank you.
Okay, next we have Kristen Johnson testifying for Hawaii Correctional System Oversight Commission. Welcome.
Hi, aloha. The Hawaii Correctional System Oversight Commission supports Senate Bill 2030. Interestingly enough, there's been some pretty recent research that has been posted by the National Institute of Justice that has really supported body cameras specifically for those who work in jails and prisons. It's been shown to reduce pretty serious incidents, inmate injuries, use of force. And the commission also just wanted to note that body-worn cameras are really important because they protect correction staff just as much as people in custody. Video evidence can quickly resolve complaints, discourage false allegations, and provide officers with confidence that their professionalism will be documented. The other piece that we wanted to mention is that clear video evidence can reduce litigation costs and settlement expenses. And it can also really help with investigations, including our investigations, and just improve training by using real-time footage to show other staff what should or shouldn't be done in these types of situations. So the commission supports this bill, and we hope that you pass it along. Thank you.
Thank you very much. Next, we have testimony from Kat Brady, Community Alliance on Prisons. Welcome.
Good afternoon. Oh, I feel like I'm sitting in a hole. My name is Kat Brady. I'm the coordinator of Community Alliance on Prisons, and my testimony is respectfully submitted on behalf of the 3,668 people who are currently incarcerated by Hawaii, 799 of whom are serving time at a corporate prison in Arizona. We're in really strong.
You put the mic
Oh,
further to you.
Yeah.
There we go.
I gotta bring it down to the.
This moves. Thank you.
This, as the Oversight Commission testified, this has really been a huge issue around the country. And currently, many states have mandated body-worn cameras. Colorado, Connecticut, Delaware, Illinois, Maryland, New Jersey, New Mexico, South Carolina, and they all use the same two words about why this is important: transparency and accountability. In LA, a jail sheriff purchased 4,641 body-worn cameras because they know that it protects staff, it protects people inside, and that it really helps when there's an investigation. Arizona just purchased 1,300 body-worn cameras. And I've been doing a lot of research on this. And one of the researchers that I just looked at is a professor from John Jay College. And he said, you know, this is really, really important because agencies must have clear policies in place around who is provided cameras and when they're activated. Secondly, agencies must have strong ways of tracking and enforcing policy compliance. And lastly, true transparency and accountability requires officials to release footage when an incident occurs. This is really important, and we hope that this committee supports this. Too many lawsuits. Thank you.
Thank you. Okay, lastly, we have Tuli Tafai testing for UPW. No, I'm sorry, not the last testimony.
Good afternoon, Chair, Vice Chair, Senator Tuli Tafai on behalf of UPW. We stand on our written testimony providing comments. I just want to reiterate, just like DCR, that this is something that will need to be consulted with the union and the employer to go ahead and move forward.
Okay, thank you. Please be available for questions. Next, we have Austin Martin testifying for Libertarian Party of Hawaii on Zoom.
Not present on Zoom, Chair.
Okay, thank you. Next, we have Veronica Moore. Written testimony and support has been submitted. Georgette Yandel. Comments have been submitted. Members, are there questions? Oh, you would like to provide testimony. Welcome.
Aloha, Angela Melody Young, testifying as an active volunteer of the Neighborhood Security Walk from District 5. So we collaborate across districts 1, 5, 6, 8, downtown Chinatown to Waianae, Ewa Beach, and Waikiki. So just a fan of public safety and in favor of appropriating the funds for body cams. So body-worn cameras are crucial in correctional facilities to enhance safety, accountability, and to provide a transparent, objective, first-person evidentiary support of incidents for what happened in correctional facilities. Because sometimes people can create things with their verbal testimony that could be subjective. And so both witness testimonies and body-worn camera footage serve as crucial different forms of evidentiary support in proceedings. And so body cams can help to reduce violence, de-escalate conflicts, and document staff-inmate interactions, which decreases liability and it assists in investigations. These devices offer a comprehensive review of operations, ensuring that actions in high-risk environments are documented and can provide evidentiary analysis to help with improving operations in facilities.
Thank you very much. Okay, is there anyone else who would like to comment on Senate Bill 2030? Okay, if not, members, any questions? I believe Chair would like to ask Michael Hoffman and UPW to respond to questions, if you can return to the table. Thank you. You know, in both the department's testimony as well as UPW's testimony, there was a reference to the need to consult. And I wanted to get a sense of typically how much time is required, you know, for consultation and review, you know, as a collective bargaining type of issue.
In the BU 10 contract, there's no time limit to the consultation period. But because DCR supports this matter, we just want enough time to get the research to provide the legislature with enough information to make an informed decision. So I want to make it clear, we support the officers wearing the cameras, but we do need to consult. We do need to develop a policy. We do need to determine the cost of the uniforms, get tamper-proof cameras, and then the data storage will be the biggest cost.
Okay.
So that's correct. There is no provision where there's a time limit, but unfortunately, I'm not part of that consultation, so I wouldn't be able to give you an answer regarding the time frame. But there will be some things that UPW would like to probably address regarding the cameras and it leading to disciplinary or termination of a lot of our employees. So that's probably something that we're going to look into, making sure protecting our workers.
Okay, thank you very much. Would kind of a rough range of 6 months, you know, delayed effective date be adequate to at least provide consultation time as well as research?
I think it'll take a little bit longer than that because we intend to contact other jurisdictions similar to our size to figure out the do's and don'ts, like the lessons learned. Also get an accurate cost of what it would take to replace the uniform, because the uniform shirts now, you cannot mount the cameras on. And then we'd also need to take a look at, again, the data storage cost will be the biggest cost. When I consulted with a Honolulu police chief, he indicated they were paying $1.2 million a year just in data storage. We have 1,800 positions with about 1,400 filled. So it would be considerably more than that for what HPD pays.
I see.
Yeah.
Thank you. Members, any further questions?
Yes, so
Senator
this particular measure as well has nothing to do with collective bargaining, right? Because
It does.
it does.
Yes.
Okay, so when's the next collective bargaining agreement?
Well, our contract is actually at the beginning of our current contract.
Oh, okay, so that'll take going through session but I tend to kind of, you know, agree with the chair, the concerns if there's a delay. I can see there needs to be a delay because, you know, considering, you know, the cost as well as, you know, now we're including not only the body cameras, but we're including the other things like the uniforms. Is it, you know, compatible that it can take, you know, the cameras as
Right.
well. So you'll have to go and look for concessions or, you know, areas of who supplies it as well. So I think it's more like doing a delay or moving this to, you know, probably even July of 2027. I mean, you know, it's a lot to do. It's not, I can understand, you know, the work that needs to do in order to purchase and the needs, yeah. And you did say you wanted more information of what
I want to
other
provide,
areas.
right, I want to provide the legislature with enough information to make an informed decision after we check with several other jurisdictions that do this. And, you know, look at some of the lessons learned from them where we can implement more efficiently, where we don't make missteps and have to pay more taxpayer money.
Sure. And I support you know, this measure. The only thing I think at this point in time for this year, I doubt it. If, you know, it's better to move the date rather than let the bill die because there's appropriation and we know that's not going to happen this year. There's so many other needs there. So we'll see. And I'm sure that chair will we'll work out something and see what we can come up with.
Okay, I might suggest you add language that encourage DCR and UPW to work together on this with a certain deadline date.
We're saying it in public. You're
Thank you so much.
you're being recorded. Thank you.
Okay, turning to next bill on the agenda. This is Senate Bill 2109 relating to emergency preparedness communications. I believe we have Administrator Barrows testifying on behalf of Hawai'i.
That's you. Thank you.
Chair, we said it, sent in our written testimony. I just wanted to add a little bit of context to, in the past 3 years, Hawai'i spent little over $500,000 in our public messaging. We used every platform available. It was federal money that we used. We used federal grants for that. And now when UH comes out with the study that says only about 12% of our Hawaii residents are 2 weeks ready, that concerns us. So that's why we support this effort. It's a heavy lift for Hawai'i, but I think it's an important messaging, and we'd build a strategy and a team around that.
Thank you. Please stand by for additional questions.
Yes.
Stephanie Kendricks, testifying for Hawaiian Humane Society. They have submitted written test. Oh, there she is on Zoom. Thank you so much for joining us.
Aloha, Chair, Vice Chair, and members of the committee. Stephanie Kendrick with the Hawaiian Humane Society. We're in strong support of this measure. Hawaiian Humane is very involved in disaster preparedness messaging. We would ask that the committee write in providing for one's pet animals as part of the messaging that it's recommending for the department. And we would be absolutely honored to work with Hawai'i in order to help with that messaging. We have graphics, we have content, we have all sorts of things that we'd be happy to help provide with the department with in order to make sure that our families are thinking about their pets when they are preparing to leave their homes in a disaster.
Okay, thank you very much. Members, we also have Austin Shiloh Martin testifying in opposition on Zoom.
Not
Mr.
present
Martin?
not present on Zoom, Chair.
Okay, thank you. Is there anyone else who would like to testify? Please come forward.
Angela Melly Young cares. In strong support. So many of the moms and the teenagers that I get to work with in nonprofits in Maui update me about recovery events in Maui. And I get to hear about everything from animal rescue to restoring native Hawaiian plants that were impacted by the wildfire events. And so emergency preparedness for public education and communications program provides a clear action plan for guidance on how households can build and maintain 14 days of supply. But not only does it do that, it also by statute helps nonprofits organize. So when an emergency impacts communities, there's a lot of chaos and confusion, and having a comprehensive plan of action and statute empowers the nonprofits to provide for the state, county, and federal offices. And so, for example, organizing with food distribution, with food banks, and with faith-based programs, if it's in statute, then nonprofits can act with the effect of the law and can help communities get to emergency supplies. And also, so the sentence for the public service announcement, instructions for radio, television, and digital platforms, I think that's a really good policy, but you could also consider an amendment. So nonprofit resources for emergency community needs shall provide instructions for emergency resources, including mental health support, emergency food distribution, animal rescue, so that these organizations can provide for the community beyond what the state, county, and federal offices can provide. Thank you.
Thank you very much. Is there anyone else who would like to testify on this measure? Okay, if not, members, Chair proposes to take a brief recess to confer with the members, and then we'll come back into session. Thank you, members. Having had a chance to hear from some really beneficial testimonies this afternoon, we'd like to go into decision-making on a number of them. First one on the agenda was Senate Bill 2145 relating to recordings of law enforcement activities. Most of the testimonies were in strong support, and Chair would like to recommend that we pass this measure in an unamended form. Any questions, discussion? If not, Vice Chair.
Voting on Senate Bill 2145, the recommendation is to pass unamended. Chair.
Aye.
Vice Chair votes aye. Senator Hashimoto excused. Senator Inouye.
Aye.
And Senator DeCourt.
Aye.
Chair, the recommendation is adopted.
My apologies. I would like to take one brief recess. We forgot. Okay, returning to the agenda, Senate Bill 2151 relating to emergency management. There were a number of good recommendations that were offered by Earth Justice as well as the Public First Center. And Chair would like to propose that we amend this measure to incorporate the language proposed by Earth Justice and to leave the public records section for Judiciary Committee to work on. Any questions, discussion? If not, Vice Chair Lee.
Voting on Senate Bill 2151, the recommendation is to pass with amendments. Chair.
Oh, I vote aye.
Vice Chair votes aye. Senator Hashimoto excused. Senator Inouye.
Aye.
And Senator DeCourt.
Aye.
Chair, the recommendation is adopted.
Thank you. On Senate Bill 2030 relating to corrections, Chair would like to note that in light of the comments from the department as well as the collective bargaining representatives, we'd like to amend the bill to extend the effective date out 1 year. So that would be July 1, 2027. Any questions, comments? Okay, if not, Vice Chair Lee.
Voting on Senate Bill 2030, the recommendation is to pass with amendments noting Senator Hashimoto excused. Are there any reservations or noes? Seeing none, the recommendation is adopted.
Okay, thank you. Turning to the last measure on the agenda, Senate Bill 2109 relating to emergency preparedness communications. Chair would like to defer this measure since there are several bills that have been introduced in the Senate that also cover this topic, and we'd like to see if we might be able to combine them so that we have a very comprehensive program for both communications as well as preparedness. Any comments? If not, thank you so much, members. We are adjourned.
Good.